Ripeness is always an issue when you ask a federal court for a declaratory judgment. Why? Because declaratory judgments are anticipatory. You're asking the court to declare your legal rights before anything actually happens. And courts ask, is this too hypothetical? Courts look at two main factors. First, how much hardship will you suffer without immediate review? This is where the real decisions get made. A business challenges a regulation. Complying costs millions. Not complying risks massive penalties. The court says, significant hardship, this is right. You shouldn't have to choose between wasting money on compliance or risking penalties to challenge an invalid regulation. An individual challenges a criminal law. Violating it risks arrest and prosecution. The court often says hypothetical hardship, not right. Wait until you're actually charged. But that's the point. People don't want to risk prosecution just to challenge a law. See the pattern? Economic harm to businesses counts. Risk of criminal prosecution to individuals? Less compelling. The second factor, does the court have everything it needs to decide? Is this a purely legal question, or does it depend on unknown future facts? Purely legal questions support ripeness. If you're challenging a statute's facial constitutionality, that's a legal question. Does this law violate the First Amendment? The court doesn't need to wait for specific applications. The legal issue is crystallized right now. But if the challenge depends on how the law will be applied in your specific circumstances, courts often find that unripe for litigation. We need to see how this plays out in practice. The problem is courts get to decide what counts as purely legal versus fact-dependent. Post-Dobbs abortion cases show this manipulation. Doctors seek declaratory judgments about medical exceptions in abortion bans. When can they legally perform abortions? That's a statutory interpretation, a purely legal question. But courts say, not right. We need specific factual scenarios. Translation, we don't want to clarify this law until someone's prosecuted. First Amendment challenges usually get ripeness more easily. Courts recognize that waiting chills protected speech. You can get a declaratory judgment that a law violates your speech rights without first violating it and getting arrested. But challenge other criminal laws the same way? Too hypothetical. The declaratory judgment was invented to let people know their legal rights before violating the law. Ripeness doctrine often defeats that purpose. You can get a declaration of your rights only after you've risked violating them. By then, you don't need a declaratory judgment. You need a defense. These two factors, hardship and legal readiness, sound neutral, but courts apply them selectively based on who's suing and what's being challenged. Ripeness isn't about whether courts have enough information to decide. It's about whether courts want to decide.